I'm reading from chapter 15, Assignment of Rights. This is the Louisiana Civil Code, chapter 15, Assignment of Rights, article 2646. All rights may be assigned with the exception of those pertaining to obligations that are strictly personal. The assignee is subrogated to the rights of the assigner against the debtor. Acts 1993, number 841, section 1, effective January 1st, 1995. Article 2645, the assignment of rights is effective against the debtor and the third persons only from the time the debtor has actual knowledge or has given notice of the assignment. If a partial assignment unreasonably increases the burden of the debtor, he may recover from either the assigner or the assignee a reasonable amount for the increased burden. Acts 1984, number 921, section 1. Acts 1985, number 95, section 1. Acts 1993, number 841, section 1, effective January 1st, 1995. Article 2644, when the debtor without knowledge or notice of the assignment renders performance to the assigner, such performance extinguishes the obligation of the debtor and is effective against the assignee and third persons. Acts 1933, I redact that. Acts 1993, number 841, section 1, effective January 1st, 1995. Article 2645, the assignment of a right includes its accessories such as security rights. Acts 1993, number 841, section 1, effective January 1st, 1995. I won't even be reading them no more. Article 2646, the assigner of a right warrants its existence at the time of the assignment. The assigner does not warrant the solvency of the debtor, however, unless he has agreed to give such a warrant. Article 2647, reserved. Article 2648, an assigner who warrants the solvency of a debtor warrants that solvency at the time of the assignment only, and in the absence of agreement to the contrary, does not warrant the future solvency of the debtor. Article 2649, when the assigner of a right did not warrant the solvency of the debtor but knew of his insolvency, the assignee without such knowledge may obtain rescission of the contract. Article 2650, a person who assigns his rights in a estate of a deceased person without specifying any assets warrants only his right of succession as heir or legatee. Article 2651, reserve. Article 2652, when a litigation right is assigned, the debtor may extinguish his obligation by paying to the assignee the price the assignee paid for the assignment with interest from the time of the assignment. A right is litigious for that purpose when it is contested in a suit already filed. Nevertheless, the debtor may not thus extinguish his obligation when the assignment has been made to a co-owner of the assigned right or to a possessor of the thing subject to the uh, lit, uh, hideous, right, litigious right, litigious right. Article 2653. I need to look what the word is. I don't have nothing else. Litigious right. Okay, let's see. Legal definition of litigious right.
According to Legal Information Institute, Cornell University, litigious is an adjective used to describe a person or company as prone to engaging in lawsuits, even if the suits are unnecessary, unfounded, or largely
retaliatory. Definition of litigious right is a civil law term that refers to a right that cannot be exercised without first being determined in a lawsuit. Oh, so, okay. Okay. Back to these civil codes and Article 2653, a right cannot be assigned when the contract from which it arises prohibits the assignment of that right. Such a prohibition has no effect against an assignee who has no knowledge of its existence. Article 2654, the assigner of a right must deliver to the assignee all documents in his possession that evidence the right. Nevertheless, a failure by the assigner to deliver such documents does not affect the validity of the assignment. When a right is assigned only in part, the assigner may give the assignee an original or a copy of such documents. Chapter 16 of a giving in payment. Of a giving in payment. Okay. Oh, I'm gonna take this and I'm gonna see if I